When several cars are involved in a crash, the insurance companies won't be quick to admit fault. The fight for compensation gets a lot harder unless you know how the law handles these cases. In this video, you'll learn how fault is determined when multiple vehicles are involved, what evidence makes the biggest difference in your claim, and the steps you can take right now to protect your compensation under Louisiana law. Hey, I'm attorney Lloyd Bourgeois, your Louisiana injury attorney, and I've spent years helping injured people fight back when insurance companies and corporate interests try to take advantage of them after a crash. If you've been in a crash and need someone in your corner, give me a call at 504-882-9867 for your free consultation. Remember, when you want to win, gotta give them the L. When you're in a crash with just one other vehicle, things can already feel complicated. But when you're part of a chain reaction involving 3, 4, or more vehicles, the confusion skyrockets. Suddenly you got multiple insurance companies pointing their fingers in different directions at different drivers, telling different stories, and you're stuck wondering, how is this ever going to get sorted out? So what is Louisiana's auto insurance system? That's a good place to start. Here in Louisiana, we follow what's called the fault-based auto insurance system. That means if you're hurt in a crash, the person who caused it, or more usually their insurance company, is the one responsible for paying your damages. That's different from no-fault states where you would automatically turn to your own insurance first, regardless of who caused the crash. Now, in a chain reaction crash, determining whose fault isn't as simple as pointing at one other driver. Each driver's actions are analyzed to figure out who contributed to causing the collision. And here's where Louisiana's modified comparative fault scheme works. This means fault can be shared. For example, one driver might be found 70% at fault, another 20% at fault, and maybe you found 10% at fault. Your ability to recover damages depends on proving who is negligent and how much their actions contributed to the chain of events. This system is designed to be fair, but in practice, it can get pretty messy, especially when multiple insurance companies are trying to minimize what they owe. So how is crash cause determined? By reconstructing the chain of events. When you've got multiple cars involved, figuring out exactly how the crash happened and when isn't just about reading the police report. In many cases, accident reconstruction becomes necessary. This involves gathering all available evidence, things like photos from the scene, dash cam footage, skid marks, vehicle damage pattern, and even statements from witnesses to piece together the exact sequence of events. An accident reconstruction expert can analyze the point of impact for each vehicle. A crash reconstruction expert will analyze the point of impact for each vehicle, the direction of movement, and the speed estimates. They may use physics-based modeling to recreate this crash digitally. The goal is to show, step by step, how the first collision triggered the second and the third, and so on. Now here's where Louisiana's comparative fault rule comes into play. Even if someone started the chain reaction by slamming on their brakes unexpectedly, another driver might still share responsibility if they were following too closely or distracted when the crash happened. The law looks at whether each driver acted reasonably to avoid causing harm, and if they didn't, what's their percentage of fault? This process can be highly technical, and insurance companies often bring in their own experts to try to shift the blame. That's why having your own legal team working with qualified reconstruction specialists can make a huge difference. So how do we prove negligence and know who the other liable parties are? Look, proving negligence is the heart of any injury case. And in a chain reaction crash, you're often proving it multiple times over, one for each person you believe shares responsibility. Negligence means showing that someone failed to act as a reasonable driver would have under similar circumstances. That could be speeding, tailgating, distracted driving, or even failing to maintain their vehicle properly, like having worn out brakes or defective equipment. But negligence isn't always limited to other drivers. Other parties could also be responsible. For example, if a commercial truck was involved, the trucking company could be liable for poor maintenance, unsafe scheduling, or inadequate driver training. If road conditions played a role, like faulty traffic signals, dangerous construction zones, a government entity might be held accountable. In rare cases, a vehicle manufacturer may share fault if there's a vehicle defect, like a brake failure, which contributed to the crash. The challenge in multi-vehicle cases is connecting the dots and showing how each party's actions or failures to act directly contributed to your injury. This requires strong evidence, consistent documentation, and often the support of expert testimony. Without that, insurance companies can more easily cast doubt on your claim. So what should you do after suffering injuries in a collision? Proving negligence later depends heavily on what you do in the moment right after the crash. First steps, always safety. Call 911, get medical help, and follow the instructions of emergency responders. Even if your injuries seem minor, get checked out immediately. Some serious conditions like concussions or internal injuries might not show up right away. If you can do so safely, try to gather evidence at the scene. Take photos of the other vehicle, license plates, skid marks, debris field, any visible injuries of you or others. Get names and contact information for witnesses. This information can be critical later because the more cars involved, the more likely it is that the stories will change and memories will fade. shape. You should also be cautious about giving statements to insurance adjusters before speaking to an attorney. In a multi-vehicle crash, insurers often try to twist words or get you to agree to their version of events that limits their driver's responsibility. Even something as simple as saying, "I'm okay," can be used against you later. Finally, get legal representation as soon as possible. In chain reaction crashes, evidence can disappear quickly. Vehicles can get repaired or scrapped, and surveillance footage gets erased. Witnesses may move away. An attorney can move fast to preserve the evidence you need to start building your case before it's too late. If you've been involved in a multi-vehicle crash here in Louisiana, the sooner you take action, the better your chances of getting the compensation you deserve. You need someone in your corner who understands how to untangle the confusion and fight for your rights. I'm attorney Lloyd Bourgeois. Call me and my team today, 504-882-9867 for your free consultation. We'll walk you through your options, explain how the law applies to your situation, and get to work on protecting your future. Remember, when you want to win, you gotta give them the L. And if you found this video helpful, hit that subscribe button and check out this next video.